The U.S. Supreme Court is hearing a New York State case about who can carry a gun in public. The justices must decide whether the Second Amendment guarantees the right to carry a firearm in public places and restrictions on carrying guns on our subways, churches, even our schools. Joining us now is Edward Purcell, a New York Law School professor and an expert on the Supreme Court and federal court system. Hello, Professor. Thank you so much for joining us on this very important case. Can you tell us about it? Who's petitioning the case, and what are they trying to get accomplished?
Well, it's a pleasure to be here. Thank you. The case is brought by the New York State Rifle and Pistol Association and two individual plaintiffs, and they are challenging a New York law which requires a license to carry guns in the city. And I think the important part of the decision is that the petitioners, that is the New York State Rifle Association, asked for presented a very broad question to the Supreme Court about carrying guns. And the Supreme Court, when it granted certiorari, granted it on a much more narrow and limited question. And that is, the petitioners wanted to bring a broad challenge to the Second Amendment. The Supreme Court granted cert on a narrower question about the licensing that the two individual plaintiffs went through, which suggests, I think, that the court is not going to make a very broad Second Amendment ruling. But that's, of course, just speculation at this point.
Just for those of us who need the education on the Second Amendment and what it says, could you go over that for us, please?
Yeah, the Second Amendment, it begins with what the Supreme Court has called a prefatory clause about a well-regulated militia being necessary to a free state. The right of citizens to carry and bear arms shall not be infringed. That's the point. And what happened was that for a long, long time before the Heller decision, which was a 2005 Supreme Court decision written by Justice Scalia, the assumption had been, and the court had basically held, that the Second Amendment was limited to rights related to militia service and bearing arms in a military sense. What the Heller decision did was simply, in effect, eliminate the prefatory clause about the militia and just leave the operative clause, as it called it, about the right of citizens to carry and bear arms. And on that basis, the court then held that there was an individual constitutional right that the Second Amendment guaranteed to carry arms. And that is, of course, the background towering precedent in the case.
So what are the justices? What can they decide? What do they take into account here?
That's, in a sense, a twofold question. One, as a matter of legal technique and formality, the court and the advocates before the court will talk about legislative history, the text of the Second Amendment, the history of the 18th century. Some of the briefs go back to the 13th century England practice in bearing arms. In fact, I would suggest that even though the legal arguments and the justices' opinions will be based supposedly on these factors, in fact, the history going back to the 13th century, the text of the amendment, the history of weapons and weapon possession and use in the United States is so ambiguous, indeterminate, and conflicting that, in fact, even though everyone will pretend they're talking about these things, in fact, it's going to be a matter of policy decision, and the justices have essentially complete discretion on deciding this case any way they want to decide it.
And as we know, the court's conservative is in the majority here. How do you expect them to rule? Is that fair to ask you that?
That's a good question, and obviously we all can take our guesses. But given the fact that the petitioners, the Rifle Association, asked for a very broad ruling on the Second Amendment, and the court granted cert on a very limited question. My guess is, if I had to guess, is that the court is going to find for the petitioners. But it's going to find for the petitioners on a very narrow ground. My guess is that they will talk about the licensing process itself in New York State and say something like it is too strict and should be loosened up in some way. But again, that's just a guess, and nobody really knows for sure.
No.
There are certainly justices on the court who want to go much further than that. And make a much broader ruling, but my guess is they're not going to command a majority.
And last question, how often is this unusual for SCOTUS to be discussing, hearing this type of a case, this type of a gun case?
Well, they heard the Heller case in 2005, and 2 years later, a case called Chicago versus McDonald, where they held that the Second Amendment also applied to the states. They haven't heard a significant gun case since. Some of the justices have wanted them to. Justice Kavanaugh, for instance, has pressed for the court to hear another Second Amendment case and try to clarify the law, I guess you would say. And this is the case that they decided to take. So this is really the first really significant Second Amendment case since the McDonald case, which is now, what, 13 or 14 years old.
Professor Edward Purcell of the New York Law School, we thank you for your perspective and information. It can be very complicated, and we really appreciate the enlightenment from you today.
It was my pleasure. Thank you for having me.
You're welcome.